Powers and responsibilities. I'm not an attorney, but I play one on TV. One of the concepts, there's a lot of legal concepts here I'll discuss with you. These have been vetted against. One thing about planning directors, if they don't talk to their city or county attorney, they're not doing their job. You learn the set of rules from a legal standpoint pretty well as you go through this sort of process. But what are the powers and responsibilities? We talked about building your community. What powers and responsibilities are bestowed by various of our Constitution, our statutes and so forth on people like yourself and others that work with you to accomplish this process? Local governments have broad authority to plan and grow and manage growth. You did not get it from the Community Planning Act. You already had it. The Community Planning Act defined it in the way that the state views that it should be done and restricts it in some ways. You already had that authority, have always had that as a charter, if you were a charter county. How many of you are charter counties here? How many are not? The distinctive difference is that a charter county acts like a municipality, whereas a non-charter county is a subdivision of the state, and so the non-charter county gets its powers directly from the state, whereas the charter county acts like a municipality and has powers that are granted directly to it from the state constitution and state statutes. Specifically, what I'm talking about here is the Florida Constitution for non-charter government says you shall have such power of self-government as provided by general or special law. So in this case, for non-charter counties, the Community Planning Act was the Chapter 163 is where you get a great deal of the power to do that. If you're a charter government, though, you shall have all powers of local self-government not inconsistent with general law or with special law approved by the voted electors, and municipality is basically the same standard. So you can do anything as a charter county or as a municipality, anything that is within the reasonable powers of government, except to the degree it is restricted by law or by a vote of the population. So you had that power and this is then, let me simply say, this same set of powers are then carried through into the statutes. When the Community Planning Act was adopted in 2011, I think probably most of you know that was a significant revision of the Chapter 163 that was adopted in 1985. And what it primarily did, and was actually touted to do, was to essentially return the power to local government, or to at least increase the self-governing role of local government. And it potentially did that. If you use it correctly, it did that. But you already had it if you were a charter county or a local. It simply did not restrict you as much as the 1985 version did and the rules that had come out of that. But my point of this only is to make the case that you have broad powers, governmental powers, to plan and manage growth. It is part of your police power. You have the ability to spend money, you have the ability to undertake programs, you have the ability to police, to exercise police power for the protection of public health, safety, and welfare. Planning and growth management it has all of those things in it, but it is fundamentally a police power exercise. And that's an important distinction and understanding to have, that's where that power comes from. But it is part of that power you always have had as a government. Now, you are engaged in this process in two distinctly different types of decision making. The first one is the making of law, and the other is applying law. And this is extremely important that we understand, and that you understand the differences, and that when you are engaged in this process in your local community, sitting on the dais making decisions, which one of these processes you are in. Because you have to wear a different hat and the rules are different. We're going to talk a lot about these rules as we go through this, and make sure that we understand what parts of this system fall under legislation and what parts are quasi-judicial. Generally, we're talking about anything having to do with the comp plan is legislative. Anything having to do with the implementation of that plan, particularly as it relates to codes, is quasi-judicial. Now, we'll be a little more specific about that, but the rules of the game are different depending on which of those activities you're engaged in. Sunshine applies to all of them. Ethics apply to all of them. Conflicts of interest apply to all of them. But the way you engage and relate with the public and with applicants and so forth is much different from legislation and quasi-judicial. The Putnam County case I mentioned was a legislative action because they were changing or proposing to amend the comprehensive plan. Sure did look like it was quasi-judicial, but it was actually legislative. All right, the Community Planning Act was adopted in 2011. It was a revision of Chapter 163, which was originally adopted in 1985, been amended many times. But the most significant revision was the Community Planning Act in 2011. What I want to do is highlight a few of the key. We've talked about you have this broad power, but the Act itself recognizes that. It says the intent is not to be interpreted to limit or restrict local government, but interpreted as a recognition of the broad statutory and constitutional powers to plan and regulate the use of land. It's a restriction or a direction in that regard. It also, under the purpose, said the purpose is to utilize the strength and strengthen local existing roles, processes, and powers of local government to guide and manage future development consistent with the proper role of local government. What is that? Well, there's a lot of we spend a lot of time defining what that is, but generally you're not going to be expected to go out and sell hamburgers on the street corner. That's probably not a proper role of local government. But essentially, within the role of proper role of government, the idea here is to strengthen your ability to manage growth in that regard. Municipalities and counties shall have the power and the responsibility to plan for future growth and development, to adopt and amend comprehensive plans, to adopt land development regulations, and to establish certain administrative instruments to accomplish that. This again is language in the Community Planning Act. Community Planning Act says thou shalt plan. It mandates that every county, all 67, and every municipality, I think at last count 410 of them, have a comprehensive plan, and then it must at least meet the standards that are further enumerated in the Community Planning Act. It can do more than that. It can't do less, but it can do more if that's appropriate for your community. And it's important to recognize that the comprehensive plan is legislative, that the legislation requires that all development and all actions taken by government in regard to the development order shall be consistent with such plan, and all development regulations shall be consistent with the plan. That's essentially what that's the relationship of the plan to the implementing tools. An action that you take must be consistent with that plan once it's been adopted. A local planning agency, which is usually a planning commission, must review land development regulations for consistency. We'll talk about this again a little bit more, but the key here is that a comprehensive plan never implements itself. It is not self-implementing, and it is not regulatory, although many of them are. Many of you probably gone through a process of trying to take some regulations out of the plan. But the plan is not itself supposed to be regulatory. It means the standard is that the actions that you take must be consistent. Who decides consistency? Who decides consistency? What's your understanding of that? You do. Now, that can be challenged. And if it's challenged, it may work its way up to a hearing officer and to the cabinet and the governing cabinet and all, through a process. But you make that determination, particularly those of you who are the elected officials. When you take an action, you are in effect, when you adopt a zoning ordinance, or you adopt a part of the plan, or excuse me, adopt a zoning, or you take some action under your zoning code, or you make a capital improvement related to a standard that you have in your plan, you actually make the decision that that's consistent. Again, one of the huge responsibilities that you have. It can be challenged, but you have to recognize that we don't have a consistency police force out there. You might think so, but a lot of times many people believe if we get it in the comprehensive plan, somehow the state's now going to enforce that. No, does not work that way. You now have a policy that the state has said this meets our standard, but the state is not going to enforce, is not going to check and be sure that you are enforcing consistency or applying consistency with your plan. They would only get involved at that stage if it was challenged in some way. Do you have citizens that think if I get it in the comprehensive plan, I must have protection that the state's now going to protect against the gas station on the corner that I don't want by my house? And that's nonsense. That is not what happens. All right. Talk about the constitutional legal foundations a little bit. There, in the U.S. Constitution, there are several amendments that pertain to what we do. And don't hesitate to, as I go through these things, to stop me and ask questions. But I expect they'll start to come a little bit more as we get into this a little bit more detail. But if you have any questions about what I was just talking about in terms of the powers of government and the relationship of the plan, consistency, and so forth, be happy to try to respond to those. All right. So several amendments to U.S. constitutional amendments that affect what we do. First one that I have on that I bring up would be the First Amendment, and that in effect says Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof and abridging the freedom of speech. Where do we encounter potentially in the things we do in planning and growth management, the things that you see in this process, where would they come into play related to the First Amendment? Pardon? Can you zone for a church? Can you regulate a church?
Regulate in what way?
Pardon?
Regulate in what way?
That's the question. Can you regulate a church?
I think you can regulate the building, certain things to do with where it can and cannot go.
Yes, you can regulate the impact of the church. You can regulate the same thing you would regulate for someone's home or someone's business, its impact. And but you cannot regulate, of course, the religious content. And you cannot have a zoning district that allows a Baptist church but doesn't allow a Presbyterian. Can't imagine why you'd make a distinction, but anyway. But the point is, you can't get into the question of content of religion, but you can you can regulate the impact. And in fact, in your zoning codes and so forth, you will have provisions that say where a church can locate. And as long as you stay within that, generally stay within that, you're regulating it the same way typically churches often run schools. If you regulate the school that the church runs the same way you would regulate a school that was public or that you would regulate a school that was a private, not associated with a church, then typically the answer will be you will fine. Impact fees, can you charge a church an impact fee? Yes. Because it's not a tax. It's a fee to offset an impact that it created because it created traffic or it caused stormwater or water sewer. So where the caution always is, if you're intruding into the free exercise of religion as opposed to how they build the building and these kind of things, then you might be this issue of respect. You can't make no law respecting establishment of religion. What about freedom of speech? We're talking about the community building process here, so where would you encounter a freedom of speech question?
Something you didn't like, an adult bookstore or something like that.
Adult uses.
Right.
is one of the areas where freedom of speech has come into play as you can't regulate it because you don't like the content of what is being produced. You can regulate where the building is and and the traffic and these kinds of things.
You don't want that type of business in your community. Can you just kind of push it out to where it doesn't fit in at all almost?
No.
No? Okay.
Well, the question was, can you zone them out?
Well,
Yeah, there are obviously things you can do to discourage it, but technically you have to permit it somewhere, and therein lies the.
If you want, we had 7.5 hours last night. We got to
Yeah.
discuss this at length, so I can get you a copy of ours.
Yeah, there are a lot of ways, to make a general statement, don't.
do what?
We talked about this for 7.5 hours.
Yeah,
last night,
right.
So I can get you a copy.
It'd probably be a very interesting conversation. There may be a lot of things that you can do. You can do a lot of things to try to control it that are entirely proper, but basically the idea is you can't simply say none of this is going to happen in my community. You've got to address it in some way that well, I won't even try to, there's not an easy answer to it.
Right.
You can be regulated, but it can't be. I will give you a quick example. When I was planning director in Hillsborough County back in the 90s, I had the pleasure of being sued by the Fantasy Men's Club as planning director, along with a couple of the county commissioners.
But that was uncomfortable.
No. No, I just had to do field surveys. No, what happened was we had a provision that says an adult business could not be within 2,000 feet of residentially zoned properties. Well, Hillsborough County is a big place, and if you were trying to do that in some small city, there's nothing that's not within two. But what we were then sued, and all I was doing as planning director was simply carrying out the code. I didn't make any discretionary judgment on it. What we then had to do, the personal lawsuits were dropped, but they still sued the county and said, you have misapplied this. There's no place that we can place an adult business under that rule. And we had in the court case, the county had to actually show that there were actually sites within the county that would meet where they could in fact place the business. And I think we identified 50 sites or something like that, and were able to sustain that particular rule. That was a separation type of rule. So yes, you can regulate them, but they're tough. And what's the other one where we get into free speech?
Liquor store?
No,
No?
not liquor stores. It he slurs your speech, but there's nothing about slurred speech. What else? Signs.
Yeah,
Signs. Yeah. Sign regulations are just, they're the bane of but no, signs, again, you can regulate in terms of their size and their location and whether you have flashing lights and all those kinds of things, but generally you stay away from the content of the sign. And by and large, you'll find most ordinances now are drafted in such a way that they are pretty clear that you're not regulating content. Political signs are interesting because and generally most ordinances, and always my recommendation is stay away from those entirely. They're only going to be there for a while. And as long as they're not on public property, you let them manifest themselves, be whatever they're going to be. You might have an ordinance that says they've got to be gone within a week of the election or something like that, but you're not going to get into any kind, I say you shouldn't be getting into any kind of issue as to a content. Political speech is one of those things that's right at the forefront quite a bit. But you can regulate where signs can be, how large they can be, how they're illuminated, all these kinds of things, as long as you, but you have to be careful about content of signs. Did somebody have a question? Okay. The Fifth Amendment is by the way, there. I think, there's a Florida. I've got it on another slide. The Florida State Constitution picks up the same provisions. You'll see the language in just a minute, but I won't. Well, let me quick. It's several down, so I'll go on back to where it is. The Fifth Amendment is where it really affects us in a very large way. And the Fifth Amendment, in effect, says that no person shall be deprived of property without due process of law, nor shall private property be taken for public use without just compensation. The planning and growth management laws in the United States are grounded in property rights. When we own property, we don't actually own that property. What do we own? We can't pick it up and move it. We own a bundle of rights. It comes from essentially English law. We own a bundle of rights. And the whole basis of our process of planning growth management, particularly when you're talking about zoning and restrictions of what's done with property, it comes from there's a understanding that these property rights that we all own or all have rights to in a property that we own are unrestricted unless there is a public interest that it can be shown to its restriction, and that restriction is reasonable. Not a lot of interpretation in that, but everything we do is actually structured around that basic concept. What we mean by due process, without due process of law, that is both substantive due process, the content of what you're doing, reasonableness of it, et cetera, and procedural. Did you do it in a way that was fair, equitable, and so forth? And I'll build on that in just a minute, but the other piece of that says that property, no private property will be taken for public use without just compensation. That's eminent domain. Florida is probably the most property-friendly state in the United States regarding eminent domain. We pay more for land, but essentially what you have to first do is to find that there is a public use. And that's an interesting question, and that's one for interpretation. Now, we probably wouldn't disagree that building the freeway is easy to establish as a public use. But we had a number of years ago, there was a state Supreme Court case called the Kelo case, which I think was New Haven, Connecticut, where there was through a redevelopment provision, the city was essentially condemning and purchasing properties along a waterfront with the prospect of then selling that property to a developer for hotels and retail or whatever. And that went to the U.S. Supreme Court, and they said, well, you can't do that. And the U.S. Supreme Court said, yes, you can. Because it came down to the question of what you defined as a public use. And the revitalization of the city had been developed, had been a concept of public use. And so the acquisition of lands, the assembly of lands, and then the redevelopment of those lands, in that case, was defined as a public use. And what many states did, including Florida, was then to go back and alter the terminology about what you meant by public use, so you have a higher test. But your community, if you have community redevelopment areas within your community, that's exactly what they are. Except that typically in Florida you don't see the eminent domain portion used as frequently as it may be in some areas. But essentially that goes to the question of what is public use, and if you condemn it for public use, then you have to pay it has to be just compensation.
Can a county eminent domain a right of way from a city?
Sure. Yeah. I mean, anything that you can define can define as a public use, and then you have authority to do it, you can use eminent domain. I don't want to get into the question of the difficulties about overlapping jurisdictions. That could get very muddy. But basically, if you can define, if you think about that, if a state's trying to build a freeway and you as a city says, I'm sorry, you can't come through our city, you wouldn't have a very good freeway system. So you can see where there has to be an overriding context. I was involved several years ago in the routing of one of the natural gas pipelines that came in across the Gulf. Actually, underwater came in somewhere down in Manatee County and went on over to Palm Beach County. Went through Okeechobee and various other places. And my job was to work with the local governments regarding the routing of that, there was going through a one-stop permitting process, so that for them to understand, you can't actually stop this. What we want to do is work with you in terms of the best routing, so it never gets into those kinds of circumstances where you're actually having to take legal steps to acquire those lands. But you had no ability to actually stop that pipeline, because it was essentially, they were commissioned by federal law and so forth, and you can understand why. I mean, you would never be able to build a natural gas pipeline from Manatee County to Palm Beach County if you didn't have the ability to acquire lands, even though through essentially what would be an eminent domain type of process. So you've got two different things here. Now, all the 14th Amendment says is that states have to do the same thing. He said that applies to the federal government. 14th Amendment says it applies to states. And then the Florida Constitution picks up on the same thing, basically the same type of requirement. Now, Florida goes further with property rights, and in Chapter 163, now Community Planning Act, it states as one of the intents is to recognize and respect constitutionally protected private property rights. All rules, ordinances, regulations, plans, programs must be applied with a sensitivity to private property rights and not be unduly restrictive. In other words, you're establishing the public purpose, and there's this reasonable, unduly restrictive would suggest there's a reasonableness to it, to what's being done. So essentially, the Community Planning Act is reinforcing pretty much the same set of concepts that you find in the federal Constitution and in the state Constitution. Now, we also go further, and we have something called the Byrd-Harris Act. There's a longer description of this in your chapter handbook there, on Chapter 2, pages 8 through 11. Many of you may often have someone say they're going to invoke the Byrd-Harris Act, and you therefore must do something, or and so forth. But the Byrd-Harris Act essentially says that, out of the federal Constitution, the takings issue arose. If you, and what we would call a regulatory taking, if you remove all reasonable use of property, if the owner is left with no reasonable use, then that can be considered a regulatory taking. That's a high restriction. Actually, the primary, and there, by the way, are some cases in your section on the handbook that discuss these various topics, and you'll find one about the Lucas case in South Carolina that pretty much established what the takings rule meant. And this was some property at the north side of the Charleston Harbor, the entrance to the Charleston Harbor. There was Mr. Lucas owned, I think, a couple of lots that were on the beach, essentially if you would go out of Charleston Harbor and you looked over to your left, you would see Mr. Lucas's property. And the state adopted a coastal building line. We do that here in Florida and so forth. But the coastal building line had Mr. Lucas's lots all out in front of it. In other words, his property was seaward of the coastal building line, and he couldn't do anything with it. And so he took it to the Supreme Court, and the Supreme Court says, no, you can't do that. That you've taken all reasonable use. And that was essentially the case that largely we rely upon as the defining one. There are others that relate to that. But that was a situation where literally every use of the property other than it to be a beach and to have sand dunes on it was taken. Had he had 300 acres and you had the coastal building line had knocked off 10, that would be highly unlikely that would have would even begun to be a takings question. But all of his property was in front of the building line.
So did they buy the land from him?
I don't know what actually happened with it.
Okay.
The remedy of it may be a different kind of thing. What would you allow him to build, or would you actually purchase it? But one of the solution would be is that you would purchase the land. Yeah, because in effect, the regulatory taking took it without just compensation. and see, so you can see how those two might actually work together. I don't know that that was what occurred, but that could have happened. The Byrd-Harris Act, in effect in Florida, said, wait a minute, there may be things, there may be actions that would go beyond a strict regulatory taking. So it attempted to define a different standard for Florida to say that regulations and other government actions may inordinately burden, restrict, or limit private property rights without amounting to a taking, and create a claim for damages in such cases. It went on to say, inordinately burdened meant that an action of government had restricted the use of the property such that the property owner is permanently unable, now that permanently is important, you can have moratorium, et cetera, for time period, now again, that gets to be a question of reasonable, is permanently unable to attain the reasonable investment-backed inspection for an existing right or a vested use or a specific use. The property owner bears permanently a disproportionate share of the burden imposed for the good of the public. And then it's set up, I think, let's see if we got it. No, I don't. If you look on the handbook reference, you will see this explained in more detail. And so what happens, and essentially if a landowner has a claim for Byrd-Harris, they essentially challenge that and it goes to a hearing officer, and there's a process that is laid out, and we describe that generally in the handbook. If he can show that an action that you took, generally it means that you've changed something, that after the act was adopted and you changed your comp plan, or you changed your codes, and the developer could show that he was burdened by that, then there might be an opportunity for a claim. Now, what you will find when you look at the handbook is there are large, if you actually get a finding that this is in fact the case, that the landowner is, meets this test, the local government has a large number of remedies available to it, one of which would be to buy the property, but others would be simply let him do what he wanted to do, and a whole range of other things in between. But what's important to recognize here is its reasonable investment-backed expectation. And that has been further defined a bit. I was working several years ago in the city of High Springs up north of Gainesville, and we were redoing the comprehensive plan, and we wanted to modify one of the density requirements on was a 100-acre parcel property that had been previously planned for commercial, 100 acres in High Springs, and it had a floor area ratio. I think probably most of you work with floor area ratio, means how much land, how much square footage can you put on the land. It was 0.75, which meant that, you know, for 100 acres, you could have essentially put 75 acres could have been building. It was simply what that said. You could have put the Mall of America on that. Mall of America is the largest mall in the United States, 4 million square feet, 20,000 parking spaces, under that set of rules. And we said, we're just trying to make these standard reasonable. And the owner said, no, I want red. I want my color to be red on that. I don't want anything changed. We had this long, prolonged discussion about it. But the idea that, and he was talking about, well, I'm going to file under the Byrd-Harris Act. Well, do you think that in High Springs, Florida, you had a reasonable investment-backed speculation that you could build the Mall of America? Probably not.
Builders don't come? No, doesn't work.
You're right. Yeah. So, and then there was a Panama City case, or in that area, recently went to the state Supreme Court where they said the developer actually has to have been turned down. He's actually had to bring the case forward, and it had been denied, and before he simply couldn't do it because you changed the plan. You'd have to actually show that I had reasonable investment-backed speculation for what I wanted to do, and you restricted that, so I couldn't do that. So it isn't quite the ogre that is often thought to be. But the point is, it does raise the bar in Florida. It doesn't mean that it's not meaningful. In some cases, it may be a very, very useful type of rule to have. But the point I really want to make with property rights is that everything we do is grounded in a property rights concept, much more so than anywhere else in the world. And so when people come in and say, well, this is terrible, you're restricting my property rights, I said, well, the whole system is structured around a property rights concept. The whole idea of comprehensive plans is to define the public purpose, why you would regulate, and et cetera. And so there is already a significant sensitivity to property rights that's built in to the system. Now, does that mean you can't cross that line? And, sure you can. In an individual case, you may trip a takings issue or really act outside of a sensitivity to property rights that might be envisioned. But generally, the whole system is designed around a property rights concept.
In rural Florida, comprehensive plans came out and some municipalities just kind of didn't know what they were doing and they
Right.
drew lines and, and now they're struggling with that. Do you see a lot of that out there?
Yeah, I think the comment you're making is a lot of plans were developed without a lot of thought sometimes and may have,
They had a deadline to meet and they had to,
yeah, and so now you have to, and so now the designation you may have on a particular property, you've got a problem and so forth. I mean, you always have the ability to amend, and usually amendments are designed to fix a problem or to advance a development scenario that wasn't envisioned at some earlier time. But there was also a lot of lines drawn without a great deal of thought about what you actually, the consequence of that might be.
right.
There's always the devil in the details here. We're trying to get some basic concepts understood first. Okay, substantive due process. We said, you can't basically interfere with property rights without due process of law. Well, one of the concepts of due process is substantive due process. Is it a proper exercise of police power? Does the regulation seek to achieve a legitimate public purpose? And is there a rational basis to think that the means used to accomplish the lawful purpose are reasonably related to achieving that purpose? So every regulation you've got could be challenged on the basis of, is it a reasonable exercise of the police power? Is there a reasonable public purpose, and is there a legitimate public purpose, and is it reasonably related? Is what you did reasonably related to solving that problem? Now, again, these are broad concepts, but in any particular case that you might apply, you could have these. You could be challenged on this kind of a basis. Most of the time, you will not get in litigation. You don't see a lot of. And I'm not an attorney dealing with this all the time, but I'm giving you my perspective from a planning director standpoint. You don't see a lot of challenges directly on this kind of a basis. What you will see is a challenge that you misapplied it to me, that you didn't apply the code correctly to me. They're not actually challenging, well, there's no legitimate purpose for the code, just it didn't apply to me in a particular way, and it's not reasonable in this particular application. So they're usually specific to the individual case, that the code you adopted and the code you applied generally didn't meet these things, but it was because of how it was applied. Because this kind of stuff takes too long. If somebody came in and said, well, your whole code, it doesn't have a public purpose, and now you're talking about lengthy kinds of litigation and so forth. So you typically don't see these challenged on a broad basis like that, but on individual application. Now, substantive due process also involves something called proportionality. Most of you, I presume, are familiar with the term proportionate share, but all of that comes from a concept of proportionality. There were two Supreme Court cases. The first one in 1987, called the Nolan case in California, which was the Nolan family, or Mr. Nolan, sued the California Coastal Commission because he had a piece of property that was on the Pacific Ocean. Apparently he had a small cottage on the property, and he wanted to build a bigger house. And the Coastal Commission was was in the review process, essentially, and they wanted a pedestrian trail along the coast. And so they said, if you want to build your house, then you have to give us some right-of-way so we can extend, so we can connect to the trail along the properties. And Mr. Nolan said, I don't want to do that. And took it to the U.S. Supreme Court, and they said he doesn't have to do that. Why? Because it had nothing to do with him building the house. There was no relationship, there was no rational nexus between getting the trail and him building the house. They were simply using his need for a permit to get him to give an easement or right-of-way so they could maintain the trail. Now, maybe in a lot of ways they could have gone about getting the trail done, but the way they did it, the U.S. Supreme Court said, no, you can't do it that way. There must be a rational nexus. Now, the reason I particularly point that out is you often are engaged in, when you're working with development reviews and so forth, improvements that you may expect or want the developer to do. And if for example, you've got a piece of property, we had some people from Santa Rosa, at least, yeah. If you want to, let's say you have somebody building down in the Navarro Beach area, and they're back over on the, on the maybe the bay side of the area, and you say, well, we want you to provide some beach access. Well, you've got to show that there's a rational nexus between what they want to do on the bay side and them having beach access, or maybe a beach cabana or something over on that they maybe dedicate to the public. So you've got to be careful that there is a rational nexus between what you've asked them to do and what their impact creates. And when we're talking about things like concurrency, adequate facilities, you're always dealing with this. When that case, we call a dual rational nexus. You've got to show the impact that's created, and then you've got to show the money you got is used to offset the impact. And so it all goes back to this notion of rational nexus. And again, in the Nolan case, it says you got to have that if you expect to regulate in that way. If you expect to, you can't regulate in a way that is not related to the impact that's being created. Yes.
So really, you're talking about a want versus a need from the public purpose as the community decides.
A little bit of that. The notion of rational nexus and proportionate share and so forth is all grounded in the notion that you can't force a developer to do something that's beyond his proportionate share or beyond an impact that he actually created. You might entice him to do it. you might or encourage him or incentivize it in some way, but you can't regulate it in a mandated way. And there is where there's a fine line oftentimes between you're asking for improvements to be made and maybe the developer is you need him to build a roadway, but what he's building is beyond what his proportionate share would be.
Based on his impact.
Based on his impact. You see what I'm saying?
Yeah.
And so you need to be aware of that concept. Now the other piece of that is rough proportionality. That was the Dolan case. I don't know that Dolan and Nolan were related, but the Dolan case was in also a California case, and Mrs. Dolan had a hardware store that sat next to a drainage easement. And again, it was a trail. The community wanted a trail along the drainage easement, and they wanted her to provide the trail, but they didn't have a plan for the trail. It was a somewhat arbitrary kind of thing. It went to the Supreme Court and said, no, you can't do that. There's got to be some rough proportionality between what Ms. Nolan is doing and what the need is. It doesn't have to be precise. So the rational nexus does not have to be precise, but there must be but it has to be there, but it also has to meet a rough proportionality concept. There's got to be some proportional basis in what you're asking the developer to do to their impact. There must be some logical connection between the problem identified, the government interest, and the solution proposed. Now this is important in what you do because you often, particularly in larger projects, you're dealing with this balance of development and infrastructure needs such as roads and schools and water and sewer and all these kinds of things, and it's very rarely ever so clean that those particularly off-site improvements that are made there's not a precise connection except in rare circumstances. So you're always dealing with this, what's the developer's share, what's rough proportionally, and what's not. Procedural due process, actually this one should have been, this one is mislabeled. This is also substantive, the vagueness question. This is also substantive. If you have a regulation that is vague, it may not pass constitutional muster. Any law is facially invalid if persons of common intelligence must necessarily guess as to its meaning and may differ as to its application. To avoid a claim of vagueness, the government must create a standard in words and pictures that permits those involved to understand what is expected or required. Now, there are many variations on this. Back in the 90s, we had a provision in Hillsborough County that in effect said that you couldn't develop in a way that would contaminate drinking water wells. But it didn't say how you were going to show that. And what that meant was, and there was actually some methodologies that related to a methodology that the Water Management District had developed. And the presumption was that if a developer came in and wanted to build in an area where they thought there might be some contamination, they had to show that they weren't doing that, they weren't contaminating, at the cost of probably several $100,000. What we did instead, now nobody challenged it on this basis, but we looked at it and said, nobody knows what this means. You don't know where this applies. And so what we did, working with the Water Management District, was actually to develop, you may have seen some of these flow cone of influence maps and so forth they will do where they show water flow. We worked with the Water Management District to develop that, and then with that map in hand, we then converted that to distinguishable features on the ground. So this is an area where you are restricted for certain kinds of uses because you have the potential for contamination. Well, the developer could then look at that and say, am I in that area or not in that area? And if I'm in that area, I can't put an underground tank in a resident, in a gas station. Before, he would have had to have done that study, and it was several $100,000, large amounts of money to do the hydrological studies that were necessary. That would have been an example of vagueness. We then converted it to something that was not vague based on data and analysis. There may be many other examples like that where a standard it's just not clear about how it applies in a particular case. And usually it's trying to prove a negative or prove that something is not the case in some way. Okay. Procedural due process. I got ahead of myself with the title. As I said, there are two different kinds of procedures that we use in this process. One is legislative when you are making law, and the other is quasi-judicial when you're applying law. The procedural due process is intended to ensure that government acts in a fundamentally fair and reasonable manner when making decisions that affect private individuals. All right. Let me go back here. In Florida, the state Supreme Court has, while you could argue that some aspects of our comprehensive planning process are quasi-judicial, in other words, if you're changing the map in your comprehensive plan for one particular developer, you could probably argue, well, that's really a quasi-judicial kind of process. But in Florida, the state Supreme Court has basically said, no, everything having to do with your comprehensive plan is legislative. So they've answered that question in Florida, so we don't have to decide that individually. They've also said that all zoning cases are quasi-judicial. You could argue that some of those are legislative in nature, but the Supreme Court has said, no, they are all quasi-judicial. There are some exceptions still to that, but I'll talk about those a little bit later. The quasi-distinction here is that on quasi-judicial is that most land use decisions implement previously determined policy decisions made in the comprehensive plan and are considered quasi-judicial. This is the case that define that, and this is extremely important concept for you. I think clarifies a lot of things, maybe questions you may have when cases come before you as you're sitting on the dais. The Brevard County versus Snyder case in 1993 said that zoning is quasi-judicial if it affects a limited number of properties. And that's what we usually see. A landowner has petitioned for a zoning change. And in those cases, it is always quasi-judicial. Where it might not be quasi-judicial is when you map the whole community or you map a large area. You might argue that that's legislative. And text changes for your zoning code are legislative because it's not applying to a specific piece of property. But by and large, zoning, everything that you would typically see, those that come before you on a routine basis are going to meet the quasi-judicial. In a quasi-judicial action, the petitioner must demonstrate consistency with the comprehensive plan. Usually they do that by saying, I've got a residential zoning classification and it's in a residential comp plan land use category and a few other density and this kind of thing. Once the developer has demonstrated consistency with the plan, if you're going to deny that, the burden has shifted. Local government must show denial serves a legitimate public purpose and not arbitrary, unreasonable, and discriminatory. And those decisions must be based on substantial competent evidence. And a tie goes to the government. Meaning that if you make a decision based on conflicting substantial competent evidence, the courts generally are not going to decide whether you were right or wrong about that. They simply want to know, did you have substantial competent evidence? And whatever decision you made was based on that, then the tie goes to the government. In other words, your position, the decision you made is presumed to be correct. So when it goes to court, essentially, they will largely look, they won't second guess you. At least that's the way it's supposed to work. They won't second guess you and say, we don't like the way you interpreted the substantial competent evidence. But did you have it? And so the weight goes to the decision maker, to the governing body, is in saying you are presumed to be correct if you made your decision based on substantial competent evidence and it wasn't arbitrary or whimsical and so forth. Usually if you made the decision because there are 50 people in the audience with red shirts on with something about, don't approve the mining process, that's not going to work. It often works politically and may not get challenged, but if it gets challenged, it's going to be a problem. Now, when I take the Putnam County case, we had more than enough substantial. What do you think we did from 1:30 to 4 o'clock in the morning? The substantial competent evidence wasn't finished until 8 p.m. And then you got a list of people who wanted to talk. So that was actually a legislative hearing, wasn't quasi-judicial. But sometimes you're overburdened with substantial competent evidence. So particularly you get into something like mining or hydrological things and you get all sorts of experts telling you all kinds of different things and you've got to weigh those kinds of things. But this is very critical in why you need to have, when you are reviewing cases and so forth, there should always be some finding of consistency. Remember, go back to what I said, your challenge is not to do something that's inconsistent with your plan. And so you're making a determination that the action we're now going to take are consistent with our plan. And once the petitioner has demonstrated that and you have agreed with that, essentially you might evaluate that. Now that burden has shifted. If you're going to do something different, you can only do it on the basis of substantial competent evidence. It can't be whimsical, arbitrary, discriminatory. And that guides every quasi-judicial decision that you make. Now, fortunately, the vast majority of decisions you make that are quasi-judicial don't have to go through a lengthy process here. They are made administratively, or you routinely, I don't know what your agendas look like, but those I've worked with, I use Hillsborough County as an example. we'd say 90% of the cases that went before the board would be approved with very little comment. Why? Because they were consistent, and they complied with the code, et cetera. That's the way the system is supposed to work. Then there are going to be those which are controversial and legitimately so. And you may well need to understand how this process works and what the burdens of proof are under, have they met a consistency plan? I've seen cases go in where they had a comp plan amendment and a zoning amendment together, and they would approve the zoning amendment, and then they look at the comp plan amendment and say, no, you can't do that. You've got to do the comp plan amendment first. Go through the review of comp plan amendment the way you would do if it was sitting here by itself, and only then can you consider the zoning case that it's supporting, and without thinking about the community, it simply reversed them and put them on, the order on the agenda was reversed, and in effect what they'd done is violated their comp plan before they had ever made the change. So you can see there's a sequence here that is related to the role of the comp plan versus the code. This is a very critical case here, and there's a description of it in the book.
Can I ask kind of a dumb question here?
Please.
If it's consistent with the comp plan and everything is fine, why are you taking public comment? I mean, I hate that. I know the answer
because there are certain things you need to exercise discretion in. I mean, you might have you may, and we look in the zoning case, you say, does this create a traffic impact that's not, because you may look at consistency, compliance, compatibility, and we also look at concurrency. You look at adequate facilities, you look at compatibility, and a project in a particular place may not meet a compatibility standard, and that may be discretionary. I mean, that's not a hard set of rules about that. That's why it's before you. If there's a hard set of rules, then your staff ought to be doing it. If there is discretion, and they often are and usually are, the key is that's focused on a few key pieces that are important, such as the traffic impact or maybe any number of other things like that, but which are not defined necessarily in the code. And if you're doing a rezoning, you've not yet said that particular use is appropriate in that particular location. And all that is part of what your process is about. One of the problems we get into is, and I will dwell on this a good bit in a few minutes, most comprehensive plans in Florida are regulatory. There's too much in them. And that's where you get into the problem. If you've got a lot of detail in the comp plan as opposed to the code, then you get into those kinds of conflicting issues. Well, wait a minute, this is what our common sense tells us in going through this process, and yet we've got this standard over here. There's also one of the court cases you will see is the Pinecrest case down in Martin County. I think it was Martin County. Several years ago that actually astounded us. This was a case where a developer had built a condo, some apartments or condominium units, as part of a planned development, and it was adjacent to single-family development. And the comp plan actually had a setback in the comp plan between that residential property and the apartments that would be built on the adjoining property. The county approved it, but said, consistently noted, it's inconsistent with that setback standard that's in the plan. And the developer went through several processes here and wound up, and actually he had then won, I believe, on the appeal. When he appealed it in the first round, the judgment was in favor of the developer, said it's okay. And he built the property. But with the disclaimer by the county that says you're doing this at your own risk. And it went to the state Supreme Court and they said, tear it down. Tear it down. And it was torn down. Because they said the primacy of the comp plan. It was clearly inconsistent. This was not a discretion. It was a hard number, 100 feet or something of this thing, that was in the comprehensive plan. And it was a clear violation of the plan. They could have amended the plan, but they didn't do that. And the Supreme Court said, no, you have to tear the building down, and it's not there anymore. And so one of the questions, one of the real issues you get into is what is the balance between what the comp plan does and says and what your codes do. Now, I would probably, in most cases, I generally argue I don't want to see setbacks in a comp plan unless it's a very hard reason, like you might have a coastal zone line or something like that. But typically plans in Florida are regulatory, and one of the things that is not, they don't have to be that way. And in fact, in work I'm doing and others in reforming plans is largely to take that regulatory content out and put it in, make sure it's in the codes, but the plan is not supposed to be regulatory. That's the plan gives you the basic guidelines, but then you have to apply them, and that's where the discretion comes in a lot of times. This is where excommunication in the quasi-judicial process is where you get into this. It's something that sounds like sunshine. It's not the same thing. Quasi-judicial means have you talked to the parties outside of the hearing? Whereas ex parte communication means you as a decision maker have had communication with either the developer or property owners who maybe opposing the case or something outside of a public hearing process. It is communication outside the hearing. It may prevent parties from knowing the basis of the decision, and it's generally resolved by disclosure. Most communities, I don't think it was the Brevard case, the Snyder case with that decided, but there was a state Supreme Court case that basically said that ex parte communication is not permitted in quasi-judicial issues. And then the legislature adopted some rules that allowed you to have a procedure that you would use in your community, and generally it had to do with disclosure. So if you talk to, if the developer came in and talked to you in your office, you would solve the ex parte communication problem by disclosing that in some way in the hearing or through some communication. I had this discussion. But this comes from when you're in a quasi-judicial hearing, you're the judge. I watch Law and Order, and of course, the judge never talks to anybody unless Mr. McCoy is there. You always have the attorneys in the room. It's the same idea as you do everything in the public hearing because you are acting as a judge. And again, that doesn't work particularly well in public hearings like you do, and so there is some latitude, but normally it's a disclosure. You had a question.
Do you have to disclose the evidence that you're using, or just disclose that you had a discussion?
Well, you would expect to disclose you had the discussion, but you'd also expect to disclose what you said as well, because otherwise nobody knows what was said. And what this is, and then obviously that could be in the worst kind of cases, that's a corruption kind of thing. But what you're really talking about is, was there some evidence that was presented that the other side didn't have an opportunity to rebut, or the staff didn't review, or whatever? And so typically what you're saying, well, I had a meeting with the neighborhood group and they pointed out the need that the flooding was constant in this particular drainage ditch behind their homes. What's the answer to that? And you might be, if you simply had that discussion with the homeowners in your office, you may not have gotten a full answer about what the circumstance was. That's the point, that something is going on that the other parties don't hear and don't have an opportunity to respond to.
So the ex parte communication only deals with the parties involved in the situation?
Or anybody. In other words, the idea is that you don't make a decision based on information you gained outside of the hearing process. But usually you're talking about the parties, but it might not necessarily. Your staff usually is an extension of you, but I know as a director, when I was making recommendations to elected bodies, I would not discuss. Well, we would typically have a meeting with the county commissioners, but we would stick to the very particulars of what was on the case and what we already had in our staff reports and so forth, and everybody knew we had those meetings and these kind of things. But if you had a question on traffic and you had a meeting with the Department of Transportation, just so you could clarify something, that would be something that you would probably want to disclose.
But to that point, that evidence would have to be presented in the hearing after.
Yes, that's what you want to happen. Yeah, you want that evidence in the hearing, exactly. And that's the whole intent, is to try to get all the information in the hearing so the decision makers have that and all the parties have that. That's essentially what you're trying to get. That's the goal you're trying to reach. Yeah.
So the residents of the community, would that be ex parte too?
Yeah, absolutely. That's usually where the problem lies. Well, that and the developer coming in and telling you all the great things he's going to do, and nobody, you know, and it isn't that there's anything going on in that's improper. It's that you don't know what went on in that. That's why the disclosure remedy is usually what's
So the
used.
best solution is
Not do it.
not do anything.
Well, the best solution is you don't have ex parte communication, and you rely upon the staff reports and evidence that's presented in the hearings. But it's very hard to do, particularly in small communities that where you don't have somebody at the grocery store say, "Well, let me talk to you about." It's just very hard to do that, and so the simple remedy is, if it occurred, you disclose it.
You know, the residents want to talk to their county commissioner, and you're almost prohibited to talk to them.
That's right, and that's why it's very uncomfortable. And that's, in legislative, that's just fine. In fact, you're encouraged to do that and all that. But in quasi-judicial, you are restricted in that regard, and you would actually jeopardize decisions if you didn't follow some kind of rule here. And again, generally it is the disclosure, and this doesn't generally become much of a problem. I haven't generally observed. You say, I had this meeting, and here's a question that came up, and I want to get this before the record and get it answered.
What are you violating if you don't disclose?
Well, you don't then have you violated the basic principle of a quasi-judicial hearing, that is that you have a fair decision maker and everybody has all the information. And those are sort of basic principles of a quasi-judicial hearing. And so you've jeopardized you've tainted the outcome. Whether it had any significant effect or not, it still, the procedure is tainted, and there's a perception that it's improper. And so that's essentially what you're doing, is you just simply have to recognize in this case you're a judge, and you're acting in the same way a judge does to preside over the process and making sure that all the pieces are there and there is a fair hearing. Anyone involved in the hearing has a right to an objective decision maker. That's the point. Doesn't mean you don't bring values and things to the hearing, but you've not made a decision before you came into the room. And so that's and we'll a lot of what we talk about a little bit later on decision making, we'll get into some of these things. Substantial competent evidence. Keep in mind you got to do this on the basis of substantial competent evidence. What is that? Well, be expert opinion. Generally, that means that a person is giving expert opinion based on education and experience, an application of that experience to the case at hand, and it must have a factual basis for that. These are not hard and fast rules, but basically the rules of conduct. So if you had a traffic engineer come in, you'd want to know what his qualifications were, and you'd want to know that he actually looked at the case in hand and made an analysis of the trip generation for that case, and based on actual facts. That would be typically what you would expect of an expert. What about laypersons, a neighborhood group? Can the neighbor provide expert opinion? Or provide substantial competent evidence, not expert opinion? If someone living next door to a zoning case offers information, can that be substantial competent evidence?
Yeah.
Not always.
Can be.
Can be. Why? How can it be?
Their experience and with situation that's occurring, I suppose.
An actual observation, essentially. In other words, I live here, and I know my backyard floods 5 times a year. I see it, and I got pictures. Now, they can't offer an opinion about whether that's going to continue to happen if development occurs upstream and all that, because they don't have the I'm assuming that it's not that they don't have the qualification to make that opinion, but they can certainly submit factual information based on their own observation and their own, and then you have to weigh that, well, how valuable is that? But yes, but simply someone saying, I don't like this, or I think it's going to cause flooding upstream, or going to cause traffic problems downtown or something like that. In other words, something that goes beyond their area of expertise. They can say it, but you then have to weigh that and say, well, that isn't substantial competent evidence, and I've got to lean upon the expert. And let me also say that the most consistent substantial competent evidence that you will receive in work that you do is your staff report. Staff gives you a report that's based on information typically gained from a whole series of folks, engineers and the codes that they apply and all of that, and they give you a report that says, here is the situation pertaining to traffic and pertaining to stormwater and all that. And in many cases, that may be the only information that you have, and in most cases it is the most objective information you have, because it can build upon information provided by the developer and information provided by others. Again, you have to weigh that against other information, but it is that is often the only substantial competent evidence that you'll have in the record of a particular case. That's actually where you probably want it most of the time.